What's going on, veterans? This is JB coming to you live. I am 100% permanent total Navy Desert Storm veteran. And in this episode, I'm going to share with you secondary conditions that you probably never thought of. We're going to deal with asthma and what asthma can aggravate, if you will, on a secondary basis. So if you have asthma, take a look at this video. We're going to go after the law first. And that's all we're going to talk about is the law. From no matter when you met me online or when you start following me on Facebook, we are going to always talk about the law because the law is what wins cases, all right? VA disability is at the intersection of medicine and law. Never, ever forget that. VA disability is at the intersection of medicine and law, okay? Now, we're going to direct you to a court case right here. That was in July of 2024. This was at the Appellate Court, the VBA, the Bureau of Veterans Appellate Court, where they were ruled in the veteran's favor for entitlement to service connection for diabetes mellitus 2 to include secondary to the veteran's service-connected asthma is granted, okay? Now, this person has asthma, okay, and has aggravated diabetes mellitus 2. If you're not a medical doctor or don't work in the medical field, how in the world can asthma aggravate diabetes? And diabetes is dealing with your sugar, right? So this person submitted this claim, all right? The findings of the fact is all about the evidence. Now, the evidence of record supports a finding that the veteran's diabetes mellitus 2 is proximately due or aggravated by his service-connected asthma. Do you see that? His service-connected asthma. Okay, conclusion of the law. We always talk about the law. The criteria for establishing entitlement to service connection for diabetes type 2 as secondary to the veteran service connection have been met. Have been met. Look at that. Have been met. Keyword, asthma, have been met. According to what law? 38, United States Code and the Code of Federal Regulations. So you have a United States Code 38, and then you had a Code of Federal Regulations 38 that substantiate. Now, when you look at your reason for decision in your decision letters, you go down below the paragraph, it says service connection may be granted for this, blah, blah, blah. Service connection may be granted for this through Terra and all that other jargon that they put on your decision letter. Then you go to your reason for decision. Now, this veteran, believe it or not, served from May 1975 to November 1980. I'm moving the camera. I'm so sorry if I'm making you woozy. Now, there is no statute of limitation. Can I ask you this question? How many years is between 1975 and 2000? Is that not 25 years? And then how many years from 2000 to 2025? Another 25 years. So this person went to an appellate court and a judge in Washington, D.C. was able to prove beyond a reasonable doubt that 50 years later plus, then when he got service connected for asthma, that the asthma has caused the diabetes after service. Think about that for a second. There had to be some cold-blooded evidence. So in December of 2019, he filed an 09996, which was a high-level review, HLR, and requested the review of the 2019 decision in April 2020. The agency of original adjudication in his area issued an HLR decision on appeal, which considered the evidence of record at the time of prior August 2019 decision. Therefore, the board may only consider the evidence of record at the time of August 2019. So he could not submit any new relevant evidence. Any evidence submitted with or within 90 days from the receipt of the Veterans VA form. In April of 2021, it talks about he wanted a docket being submitted and all of that good stuff. So I'm going to just go here. If the evidence, let's go, legal criteria. Service connection may be granted for the evidence to demonstrate that a current disability resulting from injury in service. In general, service connection requires competent and credible evidence of a current disability. So we got to have a current disability. We talk about this all the time. In-service incurrence means proof in-service medical treatment records or aggravation. Keyword is aggravation. So we're arguing the fact on element number 2 that his asthma aggravated his diabetes. Number 3, a nexus between the claim in-service disease or injury and the current disability. This is the law for secondary service connections. They still got 3 elements. Now, the 4th element that we always talk about is the level of severity. So the level of severity of your diabetes, whether you're taking insulin or whatever, it will determine the rating, okay? So, service connection may be granted on a secondary basis. They're going to reiterate this. All right, service connection may be granted on a secondary basis for a disability which is aggravated by approximately due to or the result of a service-connected disease injury under a law 3.310, 38 CFR, Allen versus Brown. Why are they bringing Allen versus Brown up there? Because that's legal precedence. This is a previously decided case when, I tell you when, a previously decided case in 1995 proves this right here. To establish a service center of a secondary base, there must be, number 1, evidence of a current disability. Those of you got this current disability say, oh man, I got this. Okay. Now the evidence of a service-connected disability, so now you got to have evidence of already being rated for something. Now, number 3, you need the medical evidence, again, establishing a link. Now, why are they producing this Wallen versus West? This is also legal precedence from 1998 talking about the reason why a nexus is required, ladies and gentlemen. Everything is all about the law, and I want you guys to understand. Stop playing with your claim because the stakes are too high. The tax-free income is so high, it's ridiculous. Those of you that don't have a business, do you understand every time we turn around, we're trying to expense things because the tax liability is not coming into the household, it's going outside the household. So whenever you have an opportunity to keep more of your money, it's always a good thing. But the only way we can do that in business is according to the law again. So you're trying to get tax-free income from injuries that you serve. That's something almost unheard of when it comes to making money. Now, in determination whether service connection is warranted for a disability, the VA is responsible. Who's responsible, ladies and gentlemen? The VA is responsible for determining whether the evidence supports the claim. Ladies and gentlemen, the evidence got to support the claim, okay? The evidence have to support the claim. Or is in relative equipoise. What does equipoise mean? Equipoise means you may have a negative CMP exam and you got a positive nexus, and they're going to rule in the veteran's favor. With the veteran prevailing in either event, or whether the weight of the evidence is against the claim, in which case the claim is denied. This is law, Gilbert versus Dowinski. The law on if you get a negative or a positive opinion in a CMP exam, they got to go back to Gilbert versus Dowinski. This is legal precedence from 1990. Now, you mean to tell me, ladies and gentlemen, we got a Board of Veterans Appellate Court in Washington, D.C. in 2025 or 2024 when this was ruled, they're dealing with past legal cases. We talked about 1990, 1998, when there's approximate balance of positive and negative evidence regarding any issue material to determine the benefit of doubt is afforded to the what? Claimant. Let me read that one more time, ladies. Y'all got to understand. Like, y'all going to have some CMP examiners that's going to give you a negative opinion regardless. I don't care what evidence you submit. But the law for Gilbert and Dowinski, I want you to understand when there is an approximate balance of positive and negative. Positive and negative. Sorry about the phone ringing. Positive and negative. All right. I hit the button. Let's see here. Sorry about that. All right, let's get back to it. Whenever you have a positive and negative nexus from your end, positive and negative from the CMP examiner, this is the law, Gilbert versus Dowinski, back in 1990, that they ruled in the veteran's favor. It's afforded to the claimant. All right. To deny a claim on its merits, the weight of the evidence must persuasively stand against a finding that the evidence is an approximate balance or nearly equal to the evidence that supports the claim. They quoted another legal precedent, Lynch versus McDonald. This is a Federal Circuit Court case, 2021. All right, let's go to the analysis. The veteran contends that the diabetes is secondary to his service-connected asthma. All right, especially the veteran argues that his use of corticosteroids causes diabetes. For the reasons below, the board agrees. The board agrees, and the entitlement to service connection for diabetes mellitus type 2 is granted. All right? So, initially, the board notes that the veteran has a current diagnosis, so you got to get your diagnosis. See, it's all talking about evidence. If your evidence does not support the claim, if you don't have the board certified doctors in your favor, you're not going to have a winning case. So let's go. In June of 2019, the veteran submitted a private medical opinion from Dr. MS. Now, Dr. MS is sitting there. It says a board certified physician with 27 years of experience. It matters what type of doctors you have and how long they've been practicing. Following a review of the veteran's claims file and a discussion of the relevant medical literature, Dr. MS stated that the veteran's asthma started in service and his use of cortisone inhalers led to the development of the veteran's diabetes mellitus 2. In support of this conclusion, the Dr. MS cited to 2 medical articles describing the effects of inhaled corticosteroids on glycemic status, noting that the steroids raise a person's blood glucose and can predispose them to diabetes. The only person that can bring that to attention is a board-certified doctor that knows what they're talking about. And we have those at New Life Veterans. Based on the veteran's medical history and the review of the medical literature, the private examiner opined. Opined means he gave an opinion that the veteran's diabetes is secondary to his service-connected asthma, especially his use of corticosteroids to treat his asthma condition. So it's not just the asthma caused the diabetes. It was the inhaler that caused the diabetes, the corticosteroids. In this case, the boards must determine the value of all evidence submitted, including lay and medical evidence. Another law, Buchanan versus Nicholson, court case, Federal Circuit Court in 2006. This is all law. So the evaluation of the evidence generally involves a 3-step inquiry. First, the board must determine whether evidence comes from a competent source. So when you're dealing with nexus letters, don't get it twisted. They will Google your doctors. They will undermine and question the validity of that doctor. So you trying to cut corners, this is not the place to do it if you want to win, okay? So, in other words, make a long story short, everything checked out. They considered the evidence of record. The board notes that the VA examiner and the private examiner are medical professionals competent to opine as to whether the etiology of the DM2. So what are they trying? They're trying to say the opine is at the beginning of the veteran's diabetes. There is no evidence that the examiners are not credible. Wow, this is a statement. There is no evidence that the examiners are not credible. Moreover, the examiner provided analysis based on both subjective and objective information to form an opinion based on medical expertise. Upon the review of the record, the board finds the evidence to at least be in equipoise as to whether the veteran's diabetes is secondary to his service-connected asthma. Accordingly, after resolving all reasonable doubt in the favor of who? The veteran, the board finds that the service connection for diabetes mellitus type 2 is warranted under 38 United States Code and the 38 Code of Federal Regulations. Now look down here below. T. Reynolds, the judge. Veteran law judge, Board of Veterans Appeals, and attorney for the board. This is an actual case that's just been decided July of 2024 of diabetes secondary to asthma, and it was decided almost 50 plus years later. Let me straighten up this camera. I'm so excited because we are helping people have breakthroughs. And the only way you can have breakthroughs is by you doing everything by the book and by the law. This is a complete example. Veterans, stop playing with your claims. And I want you to think about this. If you know that they have all these doctors they paid a lot of money for and they hired judges and attorneys, you should bring your A game in every claim. And if you're serious about bringing your A game, I want you to click the link below, get to newlifeinsider.com right now. Let's do a free consult. Let's talk about all the opportunities, all the possibilities of secondary claims, direct claims that can be added to your rating to make your rating could be higher. This actually diabetes rates all the way up, if I'm not mistaken, to 60%. I'm not sure what the severity level of what percentage he got, but that could cost you 60% on top of a 70 that could take you all the way to 90. Or it could cost you your 100%. You could be stuck at 94. You could be stuck at a 93 and can't get rounded up to 95. But if you know secondaries and you have competent medical doctors working for you, you can get that 100%. You can get that high value claim, but you will never know if you procrastinate and you bull jive and you doubt what we're saying. Here's the law, all laws, United States Code, Code of Federal Regulations, and you got me who used the law to file one time, 11 disabilities, and got 100% permanent total. I'll talk to you soon. I'll see you on the next consult.